Welcome to the vlog today. So today I have an interesting question. It's something that has been in my career for since the beginning of my cybersecurity journey. The question of are IP addresses um, personally identifiable information? So I recall, back in 8 years ago. So this was before GDPR. It was the what was the one before GDPR? I'm gonna flake out on it. But anyway, there was a European the oh God, it almost came to me. It's EU privacy that existed that basically said IP addresses are personally identifiable information. The United States, through its states or even federally, does not recognize IP addresses as personally identifiable information. So I remember being in this meeting and one of the chief information security officers for one of the businesses said, I don't understand why IP addresses would be considered PII. And I raised my hand and, former law enforcement, I said, because there are literally, that's how the law enforcement does this investigation. So basically, your IP address for any, as you're sitting on your computer in your house, as I'm sitting here on my computer in my house, at this particular date and time, my internet service provider, I'm the only person that has that IP address. That IP address comes back to my personal address to my home. So that is considered from the European Union standard PII because I can get it, I can trace it back to an individual because I routinely did that. That was one of the first steps in conducting an investigation. Get the logs, get source IP address, you can do geolocation now. There's a lot of things you could, even without a subpoena, you can do to try to figure out where that IP address came from. And then, of course, like I said, the United States doesn't. The COPPA, which is the Children Online Privacy Act, it takes a middle ground, right? So it says persistent IP addresses, so the same IP address. So getting back to the educational aspects of that, your IP address is static for a certain period of time. A lot of times with internet service providers. So, for instance, my IP address I have right now, I'll have it. I don't know what AT&T's um, time frame is. Let's say it's 30 days. It used to be 30 days. So for 30 days, I get the same IP address unless I do something different. So like yesterday when I had to unplug my router and plug it back in, it'll give me another IP address. And that lease or that license could last for another 30 days. So that when the investigation happens and they say, okay, well, give me the subscriber information for this individual IP address, it gives you everything. So, yes, I consider IP address to be personally identifiable information just because you can get it back to an individual person or an individual location. It could be a home location, it could be Starbucks, whatever that may be. But that's how I explained it to that particular executive, and he said, "Well, there now you have it." So in this particular case, it was about the New York Times wanting a Freedom of Information Act request. So there was some FCC rule that some they had comments posted on the rule. Some people thought it was bots that were doing it. So the Times did a Freedom of Information Act request requesting a source IP and user headers. So basically, as you're surfing the web, there are certain things that tells it tell it, it'll tell about you as a person. So if I'm hopping, going to different websites and doing all this, you've seen the cookies and all that. They have these little tags that actually mark who you are as you're hopping through all of these places. That's how you get the targeted advertisements that you get. And it was very interesting to me, these two pieces of information and why the Times were requesting source IP and that type of detail when they were trying to prove, I guess, that these were bots that were doing these comments and not real people. But it was intriguing. But the court came back um, and said, just because, okay, so when you do a comment and the FCC comments, they said your name and I think your email address, your name and address will be made public. So the Times was arguing that you don't have they were warned that things were being made public. So this information about IP address and the headers was they should have known that they was giving that away. Well, that's not necessarily true. If I make a comment and I leave my name, or if I leave certain information, I'm giving you certain information. That's one thing. I don't think me giving you my name and email address or my name and physical address means you get access to my, IP address so you could track it down or whatever. But it was really intriguing. The court eventually said that the the they did a test between, and this is what they do in the law, the Freedom of Information Act balancing test, where they said the rights of the citizens in this particular case, even if they handed over a name and address, it didn't even have to be an address. It could have been a business address. Who knows what this address would be? The fact that they handed over that information does not mean that they were handing over their IP address and this header information for the Freedom of Information Act request. So on summary judgment, basically the court says no, New York Times, you can't have this information. So very, very intriguing. It's always an argument though in the law on whether IP addresses could be either static or dynamic. Static means they never change. Dynamic means you get it every time you log on. But even with the dynamic, it's not dynamic every time. Like I said, there's usually some type of lease with that IP address, 30, 60, 90 days, that an individual user will have that particular IP address. So I've always considered IP address to be personally identifiable information for which I would have to show reasonable cause to get access to that information. Um, no, reasonable suspicion. I was confused. Reasonable suspicion, probable cause, two different things. There has to be some reasonable suspicion, some reason that I'm seeking that information through some type of legal instrument, which would be a subpoena or something like that. So I agree, I actually agree with the court on this case. I'll put the article down in the comments. So stay tuned for our random thought. Okay, thanks. Is it time for your annual wellness check? Cybersecurity and privacy programs, once implemented, can't get stale. It's very important that you take a look at those at least on a regular basis or semi regular basis to ensure that you are complying with industry best practices, that there haven't been any laws implemented in your state that actually affects what you're doing from a day to day perspective. Whether it's, trying to figure out, do I need cyber liability insurance, and what kind of insurance should I purchase? So it's very important to take a look at those programs. If you need a wellness check, please reach out to the Cybersecurity Law Firm of Texas for help. So, our random thought for today. All right, so I've been watching Zoom. So, back in April, I guess April 1st, Zoom announced this 90-day focus on security thing. And so, what they have recently done is they've purchased a startup called Keybase. Now, Keybase actually does something that Zoom said they did, which they got in trouble for. So, Zoom were saying end to end encryption on these meetings, and they implied it was 256-bit encryption, but it was actually about 128-bit encryption, right? And the encryption standard, the bigger the number for your non-technical people, the bigger the number, the more secure the encryption standard is, right? We're not going to go into the whole encryption thing. However, Zoom was saying 256. They were implying 256, or their salespeople were probably selling 256, but it was 128. So that got them into some trouble, as well as selling stuff to Facebook and things like that. So they purchased this firm called Keybase, which provides end-to-end encryption, and it's going to enhance their platform. Of course, enhance their platform means you're going to have to pay for it. So if you're using the free version, you probably won't get this technology. And then you have to understand that Keybase wasn't designed for Zoom, so there's going to be some configuration issues in order to get that platform to work with the Zoom platform and how they're working it out. But I think it's a step in the right direction. I think you should do stuff you shouldn't sell stuff that you don't do, but we know that happens in the industry all the time. They'll sell you everything that you need. Salespeople will sell it to you, and it doesn't perform, and then you get in trouble. So it's a step in the right direction. I still keep my eye on Zoom out there, and still think users need to follow the blog I did about how to effectively try to configure that platform. But hopefully, with that and that success, if when you're on the paid version, you'll get this encryption that you were actually promised to get. So hopefully, you got something out of there. And we'll talk again soon. Bye. Thanks again for listening to the Breach Whisperer blog, sponsored by the cybersecurity law firm of Texas. Don't forget to like this post and subscribe to our channel so you can get updates of when we post new things on our channel. In addition, spread the word for me, right? Let's get out there and tell a friend, and so they can all become paranoid cybersecurity and privacy people. Don't forget, if you would like to connect with me on socials, you can connect with me on Twitter at Mary N. Cheney. Use my middle initial always. For my nonprofit, Minorities in Cybersecurity, that is at Mike Leadership, and Instagram and Facebook at MN Cheney Law. And you can find me on LinkedIn just by searching for my name. So if you're interested, connect with me. Thanks again. And just remember, awareness equals knowledge.